Hey everybody, David Terrace here, head of the Federal Criminal Defense Practice at the Rawson Law Firm. We are continuing today our coverage of the Donald Trump prosecution, former president's indictment, and everything that is going to come from that. And the things that are coming from it now, things are really starting to heat up between the parties. So today is more going to just be an overview of some of the highlights of what's going on since our last video and even in the days leading up to this. Many of our viewers will probably have seen some of the more dramatic turn of events in the media regarding confidential audio file that was leaked to the media. We're going to have a separate video on the repercussions of that and how it may relate to the case. But again, today, just an overview, and then you'll be able to see our videos diving into each thing because a lot is going on. And just from the public eye, reading through the docket and kind of following along on the federal clerk, it doesn't seem like anything too crazy has really happened yet. But from a federal criminal defense attorney expert such as myself, there are a lot of things going on here. Chess match between both sides that we're really looking forward to covering for you. So kind of just starting off as a threshold matter regarding where we're at today and what are the most recent things that have happened. So now that the indictment, of course, has been unsealed, there's been the arraignment, we're starting to see the next big process, which is scheduling. And more importantly than that, and certainly more juicy than that, is the discovery process. How are the parties going to exchange discovery in this case? And the reason why this is so unique than any federal indictment, any federal prosecution in the history of our country is we have a case involving classified documents, and that inherently, whenever we have a case involving national security concerns or classified documents, a certain statute, a certain order kicks in, which is called the Confidential Information Protections Act. The way that the Confidential Information Protections Act, or CIPA, is going to play out here is going to be extremely interesting because it puts an immense amount of burden on the defense, more so than the government, as far as what the parties, both parties, but really the defense, are able to do with the confidential information and how they're able to access it and use it in their defense. So on the one hand here, we have the most high-profile case by far in American history. We have legal commentators, we have former judges and current judges, and of course members of the media and professors saying that of all cases in the history of the federal justice system, this needs to be the case where transparency to the public is of utmost priority. This case in and of itself, indicting a former president who's currently running for re-election for the first time, implicates transparency, public access issues more than any case could ever possibly do so, especially considering the polarizing nature of the prosecution and of the parties involved here. So this confidential CIPA, we refer to it as, sets a series of very strict guidelines regarding how these confidential documents that are at the heart of this case be disclosed. We're going to talk about in another video how these rules are extremely favorable to the government and not so, the opposite of so, to the defense in Donald Trump's case. And that's going to become a huge part of the discovery here. Other aspects of the discovery that have gone on so far are that the judge has issued a protective order over the discovery, meaning that no party, and more so the defense, but the burden is on the government as well, can disclose any of the discovery that's going to be turned over in this case. And now the unclassified discovery, what's called Production 1 by the government, has already been turned over. But there is a protective order, which former President Trump's team did agree to, as we often do in court. But it does say, and normally we agree to it because it wouldn't be beneficial for our client to make his discovery public anyways. We want our client keeping things within the firm, right? Not so much the case for former President Trump. He has every intention, clearly, over the past days, over the past hours since this video, of making public statements about his feelings on the law, about the prosecutors and the procedure so far. So he's going to have to be really, really careful now, because that protective order does say that not only can former President Trump not keep any copies of the discovery, but he can't talk about the discovery with anybody except for his counsel. So there's that restriction there. You add on SIP on top of that, and we're talking about some real difficulties, not only for any of our cases when dealing with confidential military secrets, documents that are considered classified, national security concerns, but also that we have Donald Trump's most favorable and perhaps most successful theory of defense or strategy of defense is to be judged by the public, and that is more so considering where his trial was ultimately set, which is, as of now, in the Fort Pierce district. And in those juries, and the jury pool that the Fort Pierce district is going to pull from, and the potential jurors, there's going to be a lot of debate over the discovery, what is private, what is not private, how are the parties going to litigate, which the litigation is going to be substantial, what should be considered classified. I mean, there are rules in this Privacy Act as it relates to confidential information that says that the government has the right to review the documents that may be considered classified, what's called in camera, and ex parte, which is without the defense even present. Just the judge to determine if the documents should be turned over to the defense or if national security concerns outweigh that. It also gives them the potential ability to delete discovery, delete confidential documents if national security requires it, and it's a balancing act. Now, these are determinations that ultimately will need to be made by Judge Eileen Cannon. So, of course, there is a lot of talk in the media about whether that will be favorable to Trump based on past rulings by Judge Eileen Cannon. But South Florida, the Southern District of Florida, has such a focus on transparency, and never more so here. So there's going to be a lot of discovery motions. There's going to be a lot of litigation regarding that. The August 14th trial date was probably a shock to the special counsel because maybe he consulted with some people in South Florida where we practice, but Southern District of Florida is unique in how fast they move their cases. Now, the government is moving for a continuance of the trial date here, and we're going to talk about why. But in the coming weeks, coming days, there is going to be a substantial amount of litigation regarding how the discovery and how these classified documents and the different types of classified documents are going to be able to not only be shared with the defense, but used by the parties at trial. All in all, it is very, very favorable to the government here, and former President Trump's defense attorneys need to fight that. So far, they've been consenting to a lot of the government's motions and requests regarding hearings and discovery, but I expect that things are going to ramp up very soon. There's going to be motions. We'll talk about motion practice in another video, but a lot of things have gone on here that are abnormal, possible prosecutorial misconduct. There are motions to potentially suppress evidence related to all of the attorneys that were required, Trump's former attorneys required to appear before a grand jury, which is super, super rare. So there's going to be a lot of litigation going on here. Very, very much don't expect this trial to be able to go in December. And I'm really looking forward and hoping that President Trump's defense team really will push back on the government hard here, because so far the discovery rules are normally overwhelming for a defense attorney, and you can magnify that by 200 at least when it comes to Donald Trump and his counsel's ability to pursue discovery in its entirety, not deleted, not redacted, and prepare their defense in this case. So we're expecting a lot of motions, a lot of litigation regarding the grand jury, which we'll also discuss in another video, and possible misconduct with the grand jury. But things are going to be really, really starting to heat up here now that we actually know what's being turned over. And last but certainly not least, regarding discovery issues here, during the initial appearance, Magistrate Goodman, who was handling the initial appearance for former President Donald Trump in Miami, imposed this rule that former President Trump was not allowed, as well as his co-defendant, were not allowed to discuss the case with potential witnesses. Huge saga coming from that, because the government recently filed a motion to impose that condition, and the government said that we would like to file and comply with that condition, the condition being that Magistrate Goodman said you have to provide a list to defense counsel so they know who these people are. It turns out there are 84 and counting, but currently 84 witnesses that the government believes, the special counsel believes, former President Trump should not be allowed to have contact with them. And on top of that, 84 witnesses in and of itself tells us a lot about the government's case. But on top of that, the government asked for this document, this list of witnesses, to be filed under seal, meaning that it would not become publicly available. Multiple media sources who have been following this for a long time have entered appearances through their attorneys, and these are the same sources, the same media sources who intervened in the grand jury, in the original investigation into the documents in order to get, and were successful in getting the search warrant unsealed. Now they're saying, no, this list of 84 witnesses, for starters, is absolutely something that should be unsealed. The public has a right to know who these 84 witnesses are. And if they can't do that, well, that's a huge breach of trust in public transparency, and can just create further issues here. Almost immediately, Judge Eileen Cannon denied the government's motion to keep this list of 84 witnesses under seal, stating that there is no basis, and the government laid no basis as to why there is a national security concern in keeping these 84 witnesses under seal, and that based on public records law and based on the need for a case like this above all cases in history to be transparent, that those 84 names should be unsealed. So that is an early, really important indication that former President Trump and his team may be in a good position here as we go into the confidentiality of the document stage of things to get some favorable rulings from the judge. So we will keep you updated on that as well. I'll finish with this. The two most highly guarded, highly secret forms of discovery that the government has in the federal, whether it's complex white collar or otherwise federal criminal cases that we at the Rawson Law Firm deal with, and that all attorneys have to deal with, is two things. One of them is grand jury transcripts. Extremely hard to get the transcripts of the grand jury because they are secret. Okay? The other is something that's known as Jenks material. Normally, in a federal case, the defense is not entitled to the statement of witnesses until the day of trial, and sometimes until the witness has actually testified. That can be very, very difficult for a federal defense attorney. You need a very experienced trial attorney to do that. Here, for a lot of reasons I can speculate on, but also reasons that I will discuss in another video that I believe are strategic ploys by the government, by special counsel here, they have been very forthcoming with that. They didn't even wait for Trump's team to request these documents. They gave, in their first production, they handed over non-classified grand jury transcripts. They handed over witness statements. Personally, I think that it is a very well thought out ploy, a scheme by the government to try and save face here and to look like they're being transparent, because so much other aspects of discovery here are going to show just the opposite. And we really need to look into this further, because there are a lot of unique and very dangerous and kind of scary rules in play as far as the defense's ability to properly prepare their case here. So thank you for listening to me here today. This is going to be an ongoing series. We're going to break down everything, so stay tuned. Thanks.